Hey, everybody. It's True Crime Wednesday. I'm your host, Lori Hellis, coming to you live. I am a retired criminal attorney and the author of that here book on the Lori Vallow Chad Daybell case. And welcome tonight. As always, I want to remind you all that this is not legal advice, but we're here to talk about the true crime cases that are in the news. And we have a lot to talk about. Before we get started, please hit the like and subscribe if you haven't already. Hit the thumbs up because that helps the algorithm. And I just want to thank you all for being here. Uh, there's a couple of things I wanted to let you know. Wanted to remind everybody that if you happen to have a copy of this book at your house, I am happy to send you a book plate signed if you would like one. So, if that is the case, you can email me and we will, I will get one out in the mail to you. And I also wanted to say tonight, rest in peace to Tina Turner. For those of you who are my generation, I was around for for she and Ike, and then around for her comeback in the 80s. And she was an amazing icon. So rest in peace. Um, so we have a lot to talk about. I'm going to save um, Kouri Richins and Dale Warner cases until later so that we can spend some time on those because those are the two that are in trial right now. But there were a few other things that I wanted to talk about before we got into those two. One thing that I wanted to let everybody know is that we are following other cases. And I am keeping track of those cases. And when things change in them, I let you know. So one of those cases is Larry Millete. That's a case out of California. His wife, Maya, disappeared. Her body has never been found. But it's been almost 5 years that this case has been pending. And Larry Millete has been in jail for quite some time on these charges. However, and he was set to go to trial this month, but yeah, he was set to go in early March. Sorry. But the defense attorneys asked for a continuation. They cited a, a recent personal loss for the attorneys and asked for more time to prepare, and the judge granted that. So that has now been moved to, why didn't I write it down on this piece of paper? May, I believe. Yeah, May 11th is when that trial will start. So we've also been following Lindsay Shiver. Lindsay Shiver is the Georgia former beauty queen married to a former NFL football player, and she is the one who was in the Bahamas and had a Bahamian lover, and she and her Bahamian lover are accused of attempting to hire a hitman to murder her husband. She has been on release now. Remember, it is a Bahamian court. Bahamas law is a little bit different than U.S. law. It really is based out of British law and procedure because they are a former British colony. So, and U.S. law and British law do vary pretty distinctly, even though U.S. law is sort of derived from U.S. common law. We have a U.S. Constitution, and we have a whole lot of other things that differentiate us from British law. So One of the things is that they are not very specific about trial dates. So we don't know what the specific trial date is at this point. It is scheduled for sometime in March, but we are not certain uh, of the exact date. The other thing is that we don't often get court rulings the same way as we get in U.S. courts. So, for example, she recently filed a motion with the court to have her ankle monitor removed. Now, you may remember she was allowed to return to the United States as long as she wore an ankle monitor. There's been a lot of back and forth about whether or not she is complying with the requirements of the court, whether or not she is um, doing all the stuff that she is supposed to be doing. However, she filed a motion with the court asking that the ankle monitor be removed because it was embarrassing, and she had the opportunity to work as a model and an influencer, an online influencer, social media influencer and model, and wanted to move back to Thomasville, Georgia, which is where her children live and where the divorce case arose, and where her former husband and her children still live. He has custody of the children. We don't know whether the judge allowed that or not. If I had to guess, I would think not, but, we don't know for sure, whether that was allowed. So, we probably will know more as the trial date gets closer. I know that there are US, outlets who are interested in the case and media outlets that will be covering it. The next case I wanted to talk about was Kelsey FitzSimmons. So Kelsey FitzSimmons was originally there was a pretrial preliminary hearing on motions scheduled for the 9th of March, and it appears that that issue um, has been resolved. Um, Kelsey FitzSimmons' lawyers filed a motion to recuse the judge that had been hearing her case. She is um, she is the Massachusetts police officer who was being served with a restraining order when there are varying reports of how things happened. She claims that she picked up a gun for the purpose of taking her own life. In the heat of that moment, the officer who was in the room escorting her, who was one of her coworkers from the police agency that she was a police officer for, claims that she picked up the gun and pointed it at him, and he shot her. She spent 59 days in the hospital, um, had multiple surgeries, was life flighted from the scene to the hospital, and was in very, very dire condition for quite a few days. She has since recovered. Initially, she was right after her release from the hospital. The judge required that she wear an that she wear an ankle monitor and that she blow into a device to prove that she was not using alcohol, called a scram device. She was having trouble breathing into it because of all of her rib fractures, her lung damage, all of those things. And when they asked to be relieved of that requirement, the judge put her back in jail. And she remained in jail really until she was able to use that scram device. She is out of jail. There are still, she was charged with first degree assault with a deadly weapon. The grand jury declined to charge her with attempted murder. So she's awaiting trial. Her trial is scheduled for the 23rd of March. And in advance of that, her defense attorneys, in including Tim Bradel, who is a very well-known New York attorney, and was involved in a lot of the Karen Reed litigation, including, I think, representing Aiden Carney, Turtle Boy. Um, he's representing her. They filed a motion to recuse the judge because they felt that she was biased against Kelsey. I think anybody who's been following the case would say, duh. Yeah. And so she was recused, sort of. What happened was the presiding judge came in and said that that judge was being rotated out of the criminal docket that she had been on and was rotating into a civil docket. And so he declared that the motion was moot, meaning no longer at issue, because the judge was being moved out. Now, that does mean that another judge is going to have to get up to speed and be ready for the trial on the 23rd. I think that's much easier for judges than it is for attorneys who are actually trying the case. So I don't anticipate at this point that there's going to be a delay. And I hope that it will be live streamed and that we're going to be able to see it. Attorney Melanie Little has been very interested in this case and has covered it extensively. She's got a lot of playlists about the background of the case if you all are interested in that. So I am hoping that we're going to be able to see it. We've seen some of the preliminary hearings, so it makes me hopeful that we're going to be able to see the trial as well. Somebody in chat asked me about about the status of Lori Vallow's Idaho appeals. So I looked it up, and just on the 18th of February, so just a few days ago, uh, they filed an unopposed motion for extension of time and an order. So the defense has requested uh, an extension on getting the opening briefs in, and it was not opposed by the state. Now, I want to remind everybody that when you have a 6-week trial, what the way that an appeal works is that the case is turned over to appellate counsel, and the appellate counsel has to review the record from the transcripts. And the transcripts sometimes take months, if not a year, to produce. In this case, where you had a 6-week trial with uh, many witnesses, many court sidebars, many objections, it it takes a lot of time to produce that transcript, because usually the way the transcript is done is that a court transcriptionist, which is someone who is certified by the court, not anybody can do this. So that court certified transcriptionist sits down, listens, and types up a transcript of the case. But that's not where it stops, because somebody else, as the transcript is being produced, is double checking that transcript to make sure that the first transcriptionist heard and recorded correctly what occurred in court. So it's a very labor intensive process, and that means that it takes a long time. Once that court transcript is produced, remember, we're talking about volumes of printed material. So we're probably talking about maybe 2 file boxes full of the written transcripts, all bound together in volumes. So the next thing that happens is that the um, defense appellate counsel then has to review all of those transcripts and note where they believe that there were errors that could be appealable. Not every error is appealable, or not every issue is appealable. But for the most part, the things that are appealable are objections and the judge's rulings. So not only are they having to read the whole transcript, but they're also having to go back through and listen to the objections, and then the transcriptionist is having to put in the sidebar conferences, which were recorded, but which weren't heard by the jury and weren't heard by the gallery. So all of that information has to go into the transcript. Once the court transcriptionist says, "I'm certifying that this is an accurate transcript of the trial," then everybody has to sit down and work through all of those volumes and volumes of transcript in order to determine whether or not there's been errors and what the issues are. They have to research those issues, and then they have to write the brief. And generally, they're limited to a page count. We have seen recently in several cases where they've asked to exceed the page count, but it is a very labor-intensive process. So it's not really surprising to me at this point. It it took almost a year, or maybe a little bit more than a year, to get the first transcript in the hands of the lawyers. Now they have to figure out what their what their appellate brief is going to look like. And they may identify 25 different errors that are potential, but then they're going to go through and they're going to winnow down the ones that they believe are their best chance at getting a new trial. So because there is a limit on how much the court will review. So they want to go through and make their strongest arguments first. That means going through and reviewing the entire transcript and deciding, kind of triaging what their arguments are going to be or what the errors are. So it's not at all surprising to me that they have now 3 times filed for extensions. And from the docket, it appears that each one of those requests was unopposed by the state. The state's not in any big rush to get this appeal going. So it's really going to be up to the defense to make that determination. So I also wanted to update everybody on Aaron Spencer. Aaron Spencer is the Arkansas father who confronted a man who had essayed his daughter, and in fact was on release, out on bail because of charges against him involving the daughter as a victim. And despite the fact that the guy was out on release, and for charges against this particular victim, he went into their house after everyone was asleep and took the daughter and drove off with her. When Aaron Spencer discovered that his daughter was gone, he used the Find My Phone app, I think, and followed them. He had reported it to the police, but they were slow to arrive and he knew where they were going. So he followed them. A confrontation ensued, at which point Aaron Spencer shot and killed the um, the kidnapper. I'm trying to do this as delicately as possible for YouTube, but he was charged with murder, and he is out on bail, uh, and is, running for sheriff in his jurisdiction, interestingly enough. But, one of the things that happened was that his attorneys filed a motion complaining about the judge. Once again, this is, kind of like, Kelsey FitzSimmons. So they complained about the judge and about the judge's bias. And the Arkansas Supreme Court, in a split decision, said that the judge had to be removed and also overturned the judge's ruling that there could be no live streaming of Aaron Spencer's trial. So the trial that was scheduled has been stayed, and they're still waiting for appointment of a new judge. Um, that's Arkansas, Dawn. Thanks for asking. So Aaron Spencer, it was from Arkansas. The Lori Vallow was Idaho, as we all know. Those were her Idaho charges. I'm sure that in the Vallow case, that we haven't even gotten to the point where there's a transcript on the Arizona cases. But Aaron Spencer was from Arkansas, and that case is still stayed. We don't know when they might set a new trial date. He is adamant that it was justifiable, and Arkansas, like many states, has a provision for not only self-defense, but defense of others. And I think he's going to make a very good argument that his daughter had already been seriously injured by this person, and he was not going to let this person injure his child again, and that that was a defense of others, that he was defending his child from further abuse. Um, it's Arkansas, so I think that argument may play better than it might in other states. Um, so that one's one I'm very interested in. I know that Bob and Ali Mata from Defense Diaries have been covering it very closely, and they actually um, are intending, I believe, still to attend the trial if and when it happens. So there were some updates also on the case of David, D4D, D4VD, the rapper. You might remember that 14-year-old Celeste Riveras Hernandez body was found in the trunk of David's Tesla. And law enforcement has played this case very, very close to the vest. The Tesla was found parked sort of away from David's residence, and it was towed because it was parked there for a long time. And in the trunk, this girl's body was discovered. One of the most interesting new developments is that a private investigator dropped 150 pages of court filings on X recently. And included in that was a lot of information about the state trying to compel witnesses' attendance at grand jury. We knew that they had issued at least one material witness warrant and gone to Montana or Wyoming to bring this person back. And a material witness warrant is if you are issued with a subpoena and you don't appear, the court can issue. It depends on the state. They call it different things. A body warrant. A lot of states call it a material witness warrant. What that means is the judge is saying this witness is material to this case, and I'm authorizing law enforcement to use whatever means necessary in order to assure that person's attendance in court. In this case, it appears it was for grand jury. So, yeah, yeah, Hella. Hi, Hella, by the way. Yeah, they arrested one guy for not appearing, and he wasn't arrested because he was suspected of being involved in the death. He was arrested because uh, he didn't show up when he was subpoenaed for grand jury. So he came in. They brought him in. They gave him a cot and three hots until he testified in front of the grand jury, and then he was released. But the interesting thing is that he was not the only one, that they have been trying to secure the testimony before the grand jury. And the grand jury filing specifically says that they are investigating one count of first-degree murder against David. So that's the first time I think we've gotten um, we've seen anything in court filings that confirms that they're actually looking at him for the murder. I don't think that that's a big surprise to anybody, but I do think it was kind of interesting, and it does confirm that. I wanted to draw your attention to a case that Andrea Burkhart is covering, and it is not a it is not a criminal case. It is a divorce case, and it is worth checking out on Andrea's channel because it's hilarious. So the way I understand it, and I didn't follow it all with Andrea, so I may have some of these facts wrong. But these two people, they're sort of maybe small time actors in Hollywood. They're not A-listers by any means. His name is, she pronounced it right, but most people are pronouncing it Ian. It's Ioan Gruffudd, Ioan Gruffudd versus Allison Evans. So he's from Scotland. They met on a set, got married, had a couple of children who they have been in this just bitter, bitter court battle over their divorce and the custody of the children and domestic violence. I mean, it makes Depp v. Heard look tame. So Andrea has been having a real field day with this. So at one point, Andrea, I think, happened to be in Los Angeles when a hearing was going on, and she sat in on the hearing. And the Alice Evans then claimed that she was somehow canoodling with this Ian Ioan Gruffudd. And and so that really got Andrea her attention, got her going. And so she's actually in LA covering this case, and it is funny. The what the hearing they're having now is about renewing his domestic violence um, order injunction against her. But the interesting part about it is that the state of California has recently passed a law that you cannot um, stipulate to giving a parent custody of children if if they have domestic violence findings against them. So I'm talking vaguely because I didn't look the law up. But apparently what it says is that there is a presumption that it is not in the children's best interest to for the person who is the domestic violence perpetrator to have legal custody of the children. So now there is now a legal presumption against the perpetrator of domestic violence being the custodial parent. So he's filed to renew this domestic violence order. There are findings on the record that she committed domestic violence. So now the judge is saying, "You guys, I can't sign an order that says that you agree that she's gonna have custody of the kids because there's a presumption it's not in the kid's best interest for them to be with her, and you can't deal that away." So, that's part of the interesting intricacies of it. Um, I did a lot of family law, so that really interested me, did a lot of domestic violence, restraining orders, those sorts of things. So it was kind of a hoot watching Andrea this afternoon going through that trial. It's going on for another couple of days. I think they're only in trial part of the day. It's not being live streamed. So Andrea is doing recaps after she gets out of trial. It's wonderful to watch. I had a blast. So I was trying to watch that in between Dale Warner and Kouri Richins. So let's talk first about Dale Warner's case. This is Michigan, I think. Uh, they all start running together, but Michigan, I believe. Uh, and this is day 7 of that trial. And I was just leafing back through my notes because I usually make a note of where of the states so I remember. And this is, yeah, Michigan. This is a really, so for those of you who might not be familiar, um, Dale Warner, sorry, got an itchy nose. Dale D. Warner disappeared, and Dale Warner reported that she was missing. They had a conflicted marriage. There had been a lot of conversation about divorce, but they own 2 or 3 different companies, and they were very like a lot of married couples who are in business, they were very enmeshed with the business. And it's often very difficult to separate the marriage from the business. So Dee disappeared. Her adult children from her previous marriage were very, very concerned about her because it wasn't like her. N- It 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 was sometimes like her to take off, but where she usually went was to her children, or they knew where she was. And suddenly had simply vanished. Her credit cards weren't used, uh, her driver's license, I mean, nothing was used, so she wasn't traveling out of the country, there wasn't any trace of her, which was odd. But Dale, her current husband, contended that she simply left because she was fed up. Um, the longer that her disappearance went on, the more concerned her adult children became. But there was no sign of Dee. And at one point, her adult children filed a civil suit to try and have her declared dead so that they could go after Dale Warner for wrongful death because they absolutely believe that he was responsible for their mother's death. And they definitely stayed on top of law enforcement, making, um, uh, being the squeaky wheel and bugging them about doing the investigation. So after a couple of years, they arrested Dale Warner even though Dee's body had never been found. Now, one of the businesses that they had was a farm, and they used fertilizer on the farm, and they used um, anhydrous pneumonia or ammonia, not pneumonia. I think is what it's called. It was a part of the fertilizer that they used. They mixed it, and they used it, and it was in these great big tanks. They look like air tanks, but they're enormous, and they were stored all over the property. So, for whatever reason, law enforcement got suspicious about these tanks, and they started inspecting the tanks, and they discovered Dee's body in sealed and welded and sealed into one of these tanks. So there has been a great deal of testimony about the movements and the comings and goings around this farm. One of the things that they evidence witnesses discussed were the fact that this tank, at one point, Dale was telling people to bring them into what they called a spray barn, and he was working on them. He said he was painting them because he couldn't sleep at night because he was so worried about Dee. But there was a lot of equipment on the farm, including a lot of pretty sophisticated welding equipment. So it appears that Dale cut the end off of one of these tanks, put Dee's body inside, and then re-welded the tank. So there were witnesses today talking about the fact that actually yesterday, today was an off day, talking about the fact that that weld wasn't factory and that it was clear that the weld had been done and then painted over, that there was definitely equipment on the farm that was capable of making that weld. There were witnesses who testified to the fact that Dale had burns on his arms that would have been consistent with um, sparks and what have you from welding. Um, there was a lot of discussion about the movement of at one point, somebody, testified about the fact that they saw Dale moving the front loader, the piece of heavy equipment with a bucket on the front, using that front loader to move those tanks around. There was also testimony about the fact that the morning that Dee disappeared, there appeared to have been tracks as if someone had brought the loader right up to the house, which would have been unusual, but maybe not unusual if he were moving her body. So there is a lot coming in. This is a circumstantial case, but it seems that the prosecution is making a very good show of connecting that circumstantial chain. So there's a lot coming in about the welding of the tank, the movement of the tank, the movement of the equipment. And so today they went out and the jury got a jury view of the property, the farm property, the house. There were there were several different operations on their property. Um, there were many acres of property, and some of it was farmed, and there were several different operations on the property. So they went out on a bus today and took a look at that site. So they will be back in session tomorrow, um, and we'll probably learn much more about uh, what happened on the jury view. There is a local news reporter who is doing the trial is being live streamed by the local news station. And there is a local news reporter there who is giving some really good recaps. So I've been trying to split my time between watching some of the Warner trial and watching Kouri Richins. So I did want to talk about Kouri Richins. I have seen online a lot of criticism about the defense attorneys. Um, well, at least one of the prosecutors wasn't has had to sort of tone his stuff down. But I'm pulling up my screen so I can share it. But there's been a lot of talk about this particular defense attorney. Her name is Catherine Nestor. She is also one of the appointed counsel for Tyler Robinson. Tyler Robinson is the man who is accused of shooting Charlie Kirk. So now I will tell you, she is not a lightweight. She is incredibly prepared. And a lot of people have said, well, she's kind of snippy with the judge. Maybe. Um, yeah, maybe. Yeah, at one point, somebody pointed out she kind of rolled her eyes and kind of threw her pen down. I mean, I think sometimes, uh, it's possible that she's a little bit more um, expressive with the court than and maybe pushes back a little bit more. In the grand scheme of things that I've seen over my career, I don't find her to be all that abrasive. I think she is doing her job. I think she's doing a good job. She's very prepared. She knows her case. Um, I wanted to point out what I thought was a really good part of her closing or her opening statement. Sorry. Um, I thought this was quite masterful, frankly. So let's just play this little bit here. Um, I have been watching the case on Gigi's stream because I like giving her the views, but she is live streaming Law and Crime. So I just want to play this little bit here.
It's everywhere. It hadn't really happened yet.
Tell me if you can hear that.
Oxys, and he sold the stronger dose. So you're going to hear and you're going to see evidence.
Can you hear that?
Kouri asked Carmen for something stronger, and that Carmen.
I want to make sure you can hear that. Okay, perfect.
Legs, take a restroom break.
Okay. There's just this little piece I want to play.
It's everywhere. It hadn't really happened yet. He was just selling oxys, and he sold the stronger dose. So you're going to hear. And at the end of this,
easy, you can start a.
Oh dear. Why do we have to have Jesse? I'm sorry. I thought I had this all queued up.
We're not going to dispute the facts. We're
Here we go.
going to dispute what the facts mean. Sometimes you can look at the same facts and see two very different results. Let me show you what I mean. Katie, can you put up slide 12?
Is it up on your screen, Katie? 1 second, please.
The judge has to give us the pass to get into the.
This happens from time to time.
So I wanted to point out this is early in the trial and they're still trying to figure out all the tech. So the judge has to let him in, and we've seen this before. It takes a little bit of time to get into the groove of the tech in the courtroom, and every courtroom is going to be different.
Okay. Brittany. Can you do me a favor? Disconnect from table 1.
Oh, oops.
Plug back in. Okay, 1 moment.
I'm going to speed this up just a little bit while they're
Here it is.
dealing with the tech.
So look at this picture of a young woman in a fur coat. See it? Now look again. You see a witch? Nose. Mouth. There's going to be times in this case where the state is going to discuss facts with certain witnesses, and they're going to show you the witch. And I'm going to take those same facts and those same witnesses, and I'm going to show you a widow. At the end of the trial, if you can still see both faces, that's reasonable doubt. The judge has instructed you that the burden of proof in this case lies with this table. Katie, can you put up slide 13? Can you make it a little bigger, please? The law presumes the defendant is not guilty of the crime charge. She's innocent right now, and you have to accept that to do your job. The presumption persists unless the prosecution's evidence convinces you beyond a reasonable doubt that the defendant is guilty. Katie, can you put up slide 14? This burden, this is a heavy burden for the state. We know that. And our Constitution gives them that burden.
So the part that I wanted to point out is just that idea. First of all, we didn't see the picture, so I wanted to pull that up. So that's what I was trying to do. Come on. To pull up that image. And so I'm going to pop that up so we can see that. So this was the image that she showed. And it's a very famous sort of psychological test. If you look here, you see the outline of the face of a young woman, dark hair with a feather in her hat. But if you look differently, you see an old woman, pointed chin, here's her nose, here's her eye, and then she's got a scarf over her head. So what the defense attorney was saying was, if you can still see both, that's reasonable doubt. I thought that was a very effective way to illustrate reasonable doubt. And I thought that she did a really good job. Now, the prosecution did a good job as well. They laid out their case very clearly and very succinctly. I mean, they gave the jury a tremendous roadmap of where the case was going to go, and that's really important when you have a circumstantial case. And clearly, this is a circumstantial case. We don't have a smoking gun. That is one of the things that I wanted to point out. In the testimony that we have heard, we didn't we have seen a lot of the first responders and all of the people who showed up in the early hours of the investigation, including the crime scene people. One of the things that you heard was that while the law enforcement did not know that this was a drug overdose, that wouldn't be known for a while after, because toxicology takes a while. But they were told that Kouri Richins and Eric Richens shared drinks before Eric Richins went to bed. And those drinks, the last of those drinks, were still in the sink. And they did not collect those cups, the fluid that was in them. They did not collect those. In fact, the crime scene person said she never even went in the kitchen. in collecting evidence. The crime scene clerk, she said on cross that she never went in the kitchen. So we have a problem. We've got a law enforcement evidence collection problem because it should have been simple. It would have been an open and shut case if they'd gone in and collected those 2 drinks, um, and found fentanyl in one of them. But they didn't do that. In fact, the housekeeper came in and testified that the next day, she came in and cleaned up the kitchen and washed those cups, put them in the dishwasher, and ran the dishwasher. So that evidence was overlooked, and that's gonna be a glaring piece of evidence, um, when the defense starts poking holes in the investigation. Because we know that the defense always goes after the investigation. We know that even in the best of cases, there can be some shoddy investigation. We saw the defense really almost entirely go after the investigation in the Karen Reed case, and it eventually resulted in a not guilty verdict for her. So the the effectiveness and the thoroughness of the investigation, or lack of that, always comes up in a defense. And it seems that in this defense, it may poke some holes in the state's case. Now, Kouri Richins is going to say he had an addiction to opioids that nobody knew about. Um, he claimed that he was taking these medications. There were 2 different medications that he was prescribed. They were medications that can be used with people who are trying to um, shake opioid addiction, but they're also used to treat Lyme disease. And Eric Richens had or had been diagnosed at some point with Lyme disease. He was a stonemason. He worked outdoors a lot. Michigan, I'm sorry, not Michigan. Utah is one of the areas where um, Lyme is more common. Although anywhere there are ticks, there's a potential for Lyme disease. So, according to Kouri said he had been treated for chronic Lyme disease. So what happens with Lyme disease is that if a person is bitten by a tick, if they receive immediate medical attention, antibiotics and what have you, for the potential of Lyme disease, um, then it is possible to treat it and it doesn't become chronic. But in cases where it's not treated initially, it can become chronic, and it has all of the hallmarks of an autoimmune disease. So, according to everything that everyone knows, he was being treated for Lyme disease. Um, there were supposed to be 90 pills in this container. There were 88, meaning that he took 2 of them. Kouri said he didn't take them for whatever reason, didn't like them, I don't know. So, but I think that the defense is going to get up and they're going to say Eric had a secret opioid addiction, that he was going to Mexico to bring in opiates, that he was getting opiates somewhere else, which is a little odd if you have a hydrocodone prescription bottle from 2016 in the house and it's got pills in it. One has to wonder how much of an addiction he could have had. But nonetheless, they're going to say that he had this addiction and that this is simply an accidental overdose. There are some things that definitely militate the other way. There's not a lot of indication that from anybody that he had any kind of a drug addiction, and the only drugs that he seemed to use routinely were THC gummies. Now, they're going to make a lot of the fact that in addition to the THC gummies that were in commercial packaging, that there were some that were in packaging, clear cellophane packaging, and that didn't have a manufacturer's packaging. Who knows? That could be because they came in a clear plastic package inside a box, and he took the package out and got rid of the box. Who knows? But the point is that when the toxicology report came back, he tested negative for THC. So he didn't take a gummy, which they're sort of claiming or trying to claim that he was taking gummies and that one of them must have been laced with fentanyl. I think there are a lot of holes in the investigation, but I also think there are a lot of holes in the defense's narrative. You have a guy who is supposedly takes an accidental overdose of fentanyl, but there are no other fentanyl. There's no fentanyl in the house. They don't find fentanyl pills. They don't find fentanyl anywhere in the house. If a person takes an overdose of something, often there's other indicia, there's other indication. There's other pills in the house. If the person is injecting opiates, which there's no indication that he was doing that, you'll find the paraphernalia, the syringe and in this case, there's zero fentanyl anywhere in the house, which is strange. And there's zero THC in his system, so he didn't take a fentanyl laced gummy, or that would be in his system. So it's a little hard to suss out where the defense is going. It's interesting that yesterday they had a dust up around jail calls. Now, you have to remember that in most cases, judges don't want the jury to know that the person who is on trial is in custody, because the jury could jump to the conclusion that if the person is being held in custody, they must be guilty, which is why people come to trial in civilian clothes. They don't come in orange jumpsuits, which is why their restraints are always out of view. They don't come wearing handcuffs or in any kind of restraints. And if they do have restraints on, they're things like the taser belt or like the leg restraints that lock, because they don't want the jury to know that. So when the defense started going into talking to the crime scene evidence person, she was asking questions about how the 911 call was secured, and so she said to the clerk, the evidence person, she was calling her the evidence lady at one point, I think. Um, anyway, she asked her about, was there a time when there were recordings of Kouri with her family? And the clerk didn't quite understand what the question was. And finally, she said, "You mean the jail calls?" Well, that created all this big hoo-ha. the defense attorney was trying to very carefully word her questions so that she didn't elicit that, and the clerk wasn't getting it. I don't think this was at all intentional on the clerk's part. I think she just didn't get what the defense attorney was trying to do, which was trying to talk about how she received and stored those calls, that there wouldn't have been any opportunity for them to be altered. Those kind of questions that she was asking about the 911 call and about all the other calls. I don't think that she intentionally blurted out, "Oh, you mean jail calls?" But it came out, and the judge then admonished the jury and said, "You're not to draw any conclusions about any of the testimony or whether or not the defendant is or has been in custody at any point. You're not to draw any conclusions about that from any of the testimony." So he kind of gave them that correcting instruction. But it's clear that the cat's out of the bag, that at least at some point, Kouri was in jail. Um, it it raises how they're going to get the walk the dog letter in and not let the cat out of the bag that it was found when they tossed Kouri's cell. So that's gonna be a little bit of a dance to try and figure out how to get that information in without also revealing that they found it when they tossed her cell. So, you can look for that as we go forward. So, um, so that's about all I have on the Richens case, other than to say that I think that Um, there are holes in both stories. I think that there are some real deficits in the way that that law enforcement conducted the initial investigation, and I think there are some holes in the defense's alternative story. So it's going to be interesting. I am really interested to see both sides' closings because I will say that I think both sides have been very well prepared. Their case is solid in terms of where they're going and what evidence is coming in, and they've done, or her defense has done a good job of trying to keep out as much of the really damning evidence. That's their job. It hasn't been super successful. We're going to get the walk the dog letter. We're going to get some pages of the novel. So they haven't done a great job, but they have given it the old college try. So I think that they have done both sides have done a really good job, and I am very interested to see how the case continues, and I'm really looking forward to closing arguments from both sides. Um, so, um, I did have one other thing, and that is that Tyler Robinson. Now, this is the the young man who has been accused of the assassination of Charlie Kirk. This case is also in Utah. And in fact, this same attorney is representing Tyler Robinson in his case as well. So she is a court-appointed attorney. Clearly, she is very experienced, um, probably death penalty qualified, and certainly experienced at murder trials. So um, there was a development that happened uh, either yesterday or this morning. I'm not positive. The defense had filed to have the prosecutor's office disqualified, the entire staff of the prosecutor's office, because one of the prosecutor's daughters was at the rally where Charlie Kirk was shot. She testified that she didn't see it happen and that she didn't really even know it had happened until after the law enforcement was trying to get the crowd out and so Tyler Robinson has not entered a plea yet. And in fact, there is a preliminary hearing set for May 18th. So the reason he hasn't entered a plea is because they haven't had a preliminary hearing. He hasn't actually been indicted yet. We've talked about this before. Utah and Idaho both favor preliminary hearings over grand juries. A lot of other states prefer grand juries. The reason it took so long to get Lori Vallow indicted was because during COVID, we had a preliminary hearing on Chad Daybell and on the initial charges, which were just the destruction of evidence charges. And after that, Lori then waived her right to a preliminary hearing, and they were both indicted on those charges. But they were continuing to investigate and trying to indict them on the murder charges. They decided that they didn't want to do a preliminary hearing because they wanted to keep as much of it secret as possible. So they held out to do a grand jury, but it was right during COVID, and it took almost a year to convene a grand jury in order to put that in front of a grand jury. So that just shows that Utah and Idaho both favor preliminary hearings over grand juries. Grand juries are unusual circumstances. So there is a preliminary hearing scheduled for May 18th. I'm sure it will be live streamed, and I will be really interested to see the preliminary hearing. Once that happens, then he will enter a plea, guilty, not guilty, not guilty by reason of insanity, whatever the plea is going to be. So in general, it's only guilty or not guilty. And if his attorneys later decide that he is going to raise the mental health defense, that is done after a plea is entered. So that wraps up everything I wanted to talk about tonight. So what do you all want to talk about? Let me know. Please, if you are here in live chat, please like, subscribe, hit the thumbs up, do all the things. Ring my bell, as Gigi says. And please do all the YouTube things. It helps us get out in the algorithm. And I want to thank everybody who has liked and subscribed. So we're ready to move on to your questions whenever you're all ready. What you got for me? Hi, Lavender Blue. Do you think they will continue with the fraud case if Kouri is found guilty of murder? So we know that they've charged some of the fraud charges to be aggravating factors in the murder case, but there is also a separate fraud case. Those are state charges, but they also could be brought, as we saw in the Murdaugh case, in federal court as well. So, I don't know, but I think that there are at least some victims, including Eric Richens' family, who are going to want these charges adjudicated. So there are other victims in those fraud cases. So insurance companies, banks that she got loans from, the mortgage fraud, those sort of things. And I think those victims are going to want satisfaction as well. And remember that those victims are likely going to want restitution. And of course, there's going to be a real question about whether or not Eric's estate can anyway be levied for Kouri's restitution. That is all going to have to get worked out in the civil trial. So the Richens family has sued Kouri civilly, and that civil trial is going to have to work out a lot of those details. But I think the family is definitely going to want those convictions, because I think they're going to help them in the civil case as well. So that's a good question. What else y'all got going on? Do we know if the family asked for an autopsy or is it standard? Hi, Grammy Cheryl. Um, in general, if a death is suspicious, so in the case where what some jurisdictions call an unattended death. So a death that is not attended by medical personnel. This person isn't sick, doesn't die in the hospital um, of a known condition. Typically, an autopsy would be requested by law enforcement. And so I don't believe the family asked for an autopsy. I suspect Kouri would have resisted an autopsy, but I think because of the circumstances that it would have been just a law enforcement decision to request one. So good question. I'm getting a little hoarse here. Hi, Sharon Hutchinson. Nice to see you in the chat. Was there ever an explanation as to why court closed early in the Richens case today? So what we were told from the beginning was the judge had a court matter that could not be rescheduled that was between 9:30 and 10:30. The judge then uh, recessed while he went to take care of this other matter. At some point, the judge came back in. It was much longer than I think he anticipated. And I suspect it got more complicated than he anticipated, but it was something that he said could not be rescheduled. So don't know what it was. Court watchers who were there in the courtroom may be able to look at the docket and figure it out. But we don't know for sure. It purely had to do with the judge. He then came back and recessed for the rest of the day. It didn't appear that there were any other issues other than the fact that this kind of stuff happens. And apparently, whatever it was something that this particular judge needed to take care of. And it wasn't something that could be postponed or that some other judge could sit in on. So that's about all we know at this point. He did say court was going to reconvene at 8:30 tomorrow morning in the normal schedule. We did hear in the Warner case that there were going to be some half days, and that had to do with a juror having to had an appointment or something. So we did hear that they were going to have, I think, tomorrow afternoon off. But in this case, the judge said we're back at it at 8:30, and it didn't appear to be anything that had anything to do with the jury or with the lawyers. It was strictly the judge's scheduling. So, and those things happen. I mean, it's a little surprising that it was something that another judge couldn't handle, that it absolutely had to be him, but it happens. So, good question. What else you got for me? Hi, HMSC1B. Sometimes your handles are mystifying. The emergency initially was a suspected overdose. When does that officially become a crime scene where police treat it as such? when they couldn't clearly figure out why he died. So once again, when you have a suspicious death, now I don't know that it was initially a suspected overdose. When Kouri Richins called police, she just said, "My husband is cold and dead." EMTs came. There did not seem to be any overt reason for his death, which in a person as young as him is suspicious. So that would have been the point at which law enforcement would have said, we need to treat this as a crime scene until we find out otherwise. So initially, no one particularly thought that it was a suspected overdose. There was talk about potentially it could have been an aneurysm. I mean, there was a lot of discussion about, is this really, what caused this death? So I, I think it's very typical when you have a young, ostensibly healthy person who dies in his bed and there's no outward reason for his death. There's no injury to the body. He wasn't strangled. He wasn't shot. There's no reason that EMS can come up with for his death. Then I think police investigate suspicious deaths. And I didn't find it at all unusual that law enforcement would step in and say, "Wait a minute, we need to understand how this person died." It could be that it is natural causes. It could be that there's something suspicious here. But in the meantime, we need to understand what caused his death. Yeah, sometimes there's a lag time, particularly it could have I mean, it could have been that the autopsy was completed and the medical examiner could have come up with a reason why. In this case, there wasn't. And, and so that definitely would trigger a law enforcement investigation to try and pin down why this seemingly healthy person died. So I don't know how long it was from the time the autopsy began that they actually identified fentanyl as a fentanyl overdose as a possible cause of death. I know that the medical examiner testified that when they discovered fentanyl in the blood, they then went back and wanted to test the stomach contents for fentanyl as well to find out what the source of the fentanyl was, whether it was injected, whether it was ingested. So, but I didn't pay close attention to the timelines. So, um, good questions, though. Definitely, when a seemingly healthy person dies, law enforcement is going to investigate if no cause of death is immediately evident. Hi, Felicia. Um, how do you feel about Nestor's interactions with the judge? Do you find her behavior typical or rude? Um, I think that it is more typical, and I think she sort of skirts the line of being a little bit disrespectful, but I think that this is more typical of really experienced lawyers. Um, a very experienced lawyer, and maybe it is sometimes the pitfall of being a really experienced lawyer, because as you are going through and you're preparing your case, you're looking at this piece of evidence that I want to get in. What are the possible objections to it? And what is my argument for why it comes in? Whether it's a document or someone's testimony or whatever it is that I'm trying to get in. And most lawyers who are experienced sort of know or figure what to expect when those objections come up. And I think that there were a couple of places where she was surprised at this judge's rulings and a little annoyed at it. And I can understand. One of the things that I didn't talk about, I actually chatted with Hella and Dolly about it day before yesterday. But one of the things that the defense attorney did was she came out and she said, um, we and the prosecution have many of the same witnesses on our witness list. And we want to streamline this both for the jury and for the witnesses. And so instead of the prosecution putting their case on, doing their direct, me doing my cross-examination, and then later in my case in chief, me recalling this witness, I want to ask my direct questions during the plaintiff's case in chief. This is common in civil cases. It is not as common in criminal cases. But she was annoyed that the judge didn't want to do it that way. Now, there's a lot of reasons why it makes sense to do it, but there's one really big reason why it doesn't make sense to do it. And the judge pointed this out. Yes, it is going to make the trial longer. Yes, it means that the defense is going to have to bring witnesses back in to ask questions. Now, in the case of Katie, Eric Richens' sister, they were able, the defense said they were able to get answered the things that were important to them so that they wouldn't be recalling her. And that was important because she very much wanted to be in the courtroom, and they were concerned that she wouldn't be allowed to be in the courtroom until she was completely done testifying. So that one worked out okay. But what the judge said was, let's remember that the prosecution puts their case in chief on. And at the end of their case in chief, they rest. And then the defense is going to make a motion for a directed verdict or JNOV or whatever that the state calls it. Okay. Essentially, the defense is going to say to the judge, the prosecution didn't prove their case, and we want you to issue a verdict before we've ever, in favor of the defendant, before we have ever put on anybody. Now, the rule says that the evidence has to be taken in the light most favorable to the prosecution. Okay. So as the judge is trying to decide whether or not the prosecution has made their case, the judge would then have to figure out all of the stuff that the defense wanted to put in out of turn and disregard all that. That's a problem. It's just complex, and it's not something a judge is going to risk doing. So the judge said, I am not going to allow you to ask your direct questions during the prosecutor's case in chief. You will have to recall those witnesses if you don't get on cross everything that you need. Because let's remember that cross-examination is only on what the direct questions were. You cannot go outside the scope of the prosecution's direct and ask questions or get into areas that were not raised by the prosecution. So you can't just go off on your own tangent or your own narrative without first, in the prosecution's case, it has to be done in your case in chief. So the judge said, I'm not going to allow you to deviate from that, because then it would make it nearly impossible to fairly give a ruling on a directed verdict motion. So she was frustrated with that. I don't necessarily know why, um, because every criminal case, the prosecution puts their case on. If the defense doesn't get everything they want in cross, they have to bring that witness back, and that witness has to answer their direct questions. That's just the process. So I'm not really clear why she was quite so put out about it, but she was. She was frustrated by that, and she sort of pushed back against the judge and said, I've never seen a judge rule that way before. Um, I, I, I wouldn't. I would have said it's more unusual for a judge to allow the defense to get into their direct during the prosecution's questions. I would feel that it would be more unusual for a judge to allow that. Now, in a civil case, it happens all the time. I mean, you get a divorce case, or you get a insurance defense case. That happens all the time. The plaintiff starts to put on their case, and the defense steps up and says, "Judge, we both have this same witness subpoenaed." In the interest of efficiency, in the interest of respecting the witness's time, the jury's time, we're just going to take the defense questions out of order. And then usually what would happen is the prosecution would ask or the plaintiff in the civil case would ask their questions, the defense would do their cross, then the defense would ask their direct questions, and the plaintiff would be allowed to do their cross. So they're really just taking the defense case out of order for the convenience of the jury and the witness. But it is not typical in a criminal case. And that's the reason why, because we do not want to throw off the judge being able to make accurate rulings on the defense motions. So hopefully that explains some of that. Yeah, I think she's really experienced. I think she's a little impatient with some of the judge's rulings, and but to be honest, I think she has been pretty respectful with the witnesses. I mean, sometimes where we see defense attorneys really come off as jerks is in their treatment of witnesses, when they're just really going hard against a witness. Now, lay witnesses, non law enforcement witnesses, I think need to be handled more delicately. I think there is a time and a place when the defense should go hard against law enforcement witnesses. But I do think that she has been very respectful with the witnesses. Yeah, she's been a little bit pushy with the judge, but not to the point where I felt like it was distracting or that it was disrespectful to the judge. And we have seen lawyers who are somewhat disrespectful of judges, and it doesn't usually go well for them, but it happens. So, good questions tonight, guys. What else you got for me? Hi, eat the food, Tina. I don't know this question. If somebody else in chat knows, maybe you can let me know. The question is, do you know if Kouri's book is still on the market? And if so, do any potential proceeds go to her children? I don't know. Now, let's be honest here. as an author, I can tell you that authors don't make huge amounts of money unless you are a wildly successful New York Times bestseller selling a million copies because you're Michelle Obama. You're not dragging down huge amounts of royalties. And it doesn't strike me that this book was widely marketed. Now, people may have more interest in it now because of the trial, but it doesn't seem to me like she was poised to for this to be a wild bestseller. So, and I honestly don't know. This book was actually written by a ghostwriter. So the person who actually wrote the book may. Oh, thanks, Don, for letting us know that it's no longer on Amazon. It was pulled when she was arrested. Um, so it's hard to say whether she paid the ghostwriter or whether the ghostwriter was supposed to get part of the proceeds. Hard to say what their arrangement was. But Kouri didn't write this book, a ghostwriter wrote it. And so the answer is it doesn't appear to be available on Amazon anymore. Um, I mean, at a minimum, probably it would go to Kouri. Um, I don't really know, and it may very well be because I'm not that familiar with the civil case. It may very well be that the family has asked for any proceeds from the book to be there. There may be an injunction against her receiving any of the proceeds. Because let's remember that uh, Slayer laws, Son of Sam laws, preclude someone from profiting from their crime. So it could even qualify under that statute as well. So good questions. Anybody else? This normal Idaho mom. Oh, hi, you. I see you a lot in Hellis chat. How likely is it that the prosecutors are taking the case at the behest of the Richens family? Supposedly, they have a lot of prominence in the area, and in Summit County, people tend to be wealthy. Um, you know, prosecutors are not going to prosecute a case strictly because the family wants them to. They have to believe that it is in the interest of justice because they are bound by ethical obligations to act in the interest of justice. They are not permitted to act as the representatives of victims or their families. So they have to start out by saying, can I bring this case in the interest of justice? And do I believe that there is sufficient evidence to get a conviction? So the prosecution has to start out with that premise. It certainly they can take into consideration and should take into consideration what victim families want, but ultimately the decision has to be made by the prosecution, by the district attorney, um, and exercising their prosecutorial discretion. So that's a good question. I mean, I'm sure the prosecutor is an elected official, and I'm sure that they want to please their constituency, but they're certainly not going to bring a case simply because the Richens family demands it. There has to be evidence that they believe they can secure conviction with. So, good question. When an attorney gets huffy with attitude, oh, hi, she opines. Oh, thank you, by the way, for your email. I appreciated that. She sent me a very sweet email. When an attorney gets huffy with attitude toward the judge, doesn't their future reputation suffer? Sometimes. It really depends on the judge. And I can say that if you are a lawyer who appears regularly in front of these judges, this judge, you and the judge know each other. And you kind of have an idea of how far you can push the judge, and the judge sort of gets you a little bit, maybe. So, I mean, I will say that judges that I regularly appeared before and had regularly appeared before for years, you develop, I won't say a relationship because it's not, but there is a collegial understanding of one another, I think. And so, no, I don't think your reputation suffers. Certainly, judges talk to one another. And if you are a problematic lawyer, if you are consistently problematic in the courtroom, judges talk to each other and judges will know. But getting a little huffy or having a little bit of an attitude is not the same as being a problematic lawyer. Um, so and I think that judges are more likely to overlook sort of the heat of battle huffiness if they know that you are a good lawyer, that you are an effective lawyer, that you get your job done, that you meet your timelines, that you don't ask for special favors from the court, that you don't, that you're actually doing your job. I think the court respects that, and judges are more likely to overlook that sort of huffy in the heat of the battle um, if you are an effective advocate for your client. If, on the other hand, you are one of those people who shows up late, doesn't get your motions in on time, doesn't do what you're supposed to do, is always doing everything at the last minute, and then you come in and get huffy with the judge, I don't think the judge is going to have much sympathy for you. So it really depends. And, a lawyer's relationship is, a lawyer's reputation is only as good as their last court appearance. So it is important to maintain that professional, collegial sort of demeanor. To be honest, I don't think that this lawyer has crossed the line. Yeah, she's been a little huffy at times, but I think that any experienced judge, and this judge is very even-handed and very experienced, would say, this is kinda typical heat of battle stuff." You're right in the thick of things, you're thinking about 6 different things at one time, you're trying to listen to the witness while you're thinking about the next piece of evidence that you've gotta present and all of the objections that might come into it, and, I mean, yeah. In the heat of that moment, you can get irritated that a ruling didn't go your way or it didn't come out the way you expected it to or the way you'd planned for. So I get that part. And I just don't think that this lawyer has overstepped in any meaningful way what I would think of as proper courtroom decorum. So, but these are good questions. And I know that there was some criticism of one of the prosecutors, one of the younger prosecutors as well, who was uh, showed that he got the message by sort of dialing it down the next day. So, um, yeah, it 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 happens, especially in cases where you have been preparing for months and months and months and, there's a lot riding on it, even if they're not high visibility, highly publicized cases. So, hi, Autumn. Um, I mean, I've been following the Reiner case as much as anyone is. I think the media is very interested in it. Um, Obviously, TMZ and entertainment uh, news reporters are very interested in it. It is a very sad case. It's very sad for so many reasons. I mean, it's sad for the uh, his brothers and sisters who now don't have their parents. it's sad for, the people who loved and will desperately miss Michelle and Rob Reiner. It's sad for him too. I and I don't we don't know enough about what was going on before. We know that Nick Reiner had some somewhat serious mental health condition. We don't know the facts leading up to everything, so we don't know the validity or the depth of the possibility for a mental health defense. And I mean, I feel very sad for his siblings who are now caught um, between their brother and the loss of their parents. I mean, it's really awful to be in that position. Um, I think the same as it was for Chad Daybell's children, to be in that horrible position of your father murdered your mother. Um, Same situation, your brother murdered your mom and dad. Um, that's a really, really hard position to be in, and unless you've been there, I think it's not one any of us want to get in their shoes and walk around. So, it is a sad case, and I mean, I'll follow it, but does it present legal issues that I think are interesting or important? Um, Not right now. I mean, right now he's entered a plea and it'll move itself ahead, but I think it's going to be a long time before we really hear anything about how the case is going to develop. So, yeah. Well, let's take a few more questions and then we will wrap up. Hey, Don Schaefer. When can I expect the bad grandma book? I need to practice. You and me both, as aspiring grannies. Well, here's what I can tell you. I think I am right on the brink of putting out the first Patreon episode of Bad Grannies. It is going to be called Chasing Justice, The Granny Files. It's going to come out on Patreon. I've almost got the first project done, and I've almost got the first part of it recorded. So I'm working on editing, and so that first episode, I'm really close, and then we should have some more episodes coming out. It has been a steep learning curve. This old granny is, or aspiring granny, is having to learn how to shoot video and edit it and how to use AI to make the captions. And I mean, it's a lot. Design the pattern, do the project. So, but the first one should be coming out shortly. It is a small quilt project, kind of a wall hanging size quilt project. And I think you'll enjoy it. It's going to be a pretty easy project. We're going to and so I'm excited about it, and I am diligently working on it. But I'm having to sort of figure out, okay, so now I teach you how to make these squares. Then I have to teach you how to put them all together. Then I have to be able to show you the finished product at the beginning. So it's all that fun editing stuff that I'm getting ready for. So Dawn, I don't know whether it will ever be a book, but I'm still thinking about it. We'll see. But it is going to be a Patreon series. So thanks for asking. I think I'm close to getting the first episode out, and we will post it all over our community page and everywhere else. So you will be able to, so you'll know as soon as it is available. So let's take a couple more questions and we'll wrap up for the night. Hi, Carla Shelves? Oh, Shives. Sorry, there's an I in there. Old eyes. Can you explain to everyone why the family had to hire handwriting experts and such to protect themselves in the civil suit, and how that evidence is included in the murder trial? Oh, this is a good question. So there are handwritten documents that Kouri created while she was in jail. One of them is the walk the dog letter. The other is somewhere around 60 pages of what she claims is a potential novel. Maybe I should say it's more of a thought exercise, to quote Dr. John. So what we know from the documents that we've seen, from the motions and the documents we've seen, is that she had an envelope, a manila envelope. It had many pages in it, and written across the front was Sky Borgman, who was her first attorney material. Now, she claims that when the prison guards came in and tossed her cell, the walk the dog letter, which is the letter that the prosecution claims was an attempt to convince her mother and brother to tell a story, to testify to something different, she claims was in that envelope. They claim that they found it in a book in her cell. So first of all, we have those two opposing things. So we have the walk the dog letter. The walk the dog letter, the reason they call it that is because the words walk the dog are across the top of it. It appears to have been directed at her mother, and it was tell Ronnie, my brother, to say this and say that, to say that Eric used to go to Mexico and brought back drugs, and to support her narrative. The other piece of it are these 60 pages that are this novel. Now, what she claims she did was she took the actual facts of the case from the beginning up until her detention hearing. And then she went off on this what if I was released at the detention hearing? She wasn't, but what if I was? And what if I left? I basically absconded from my bail and went to Mexico to find the fentanyl dealer who sold Eric the drugs. Now, this presupposes that Eric bought fentanyl from a drug dealer in Mexico, which is her story. So she then goes off on this sort of fanciful story about what if. It includes the character, the main character includes taking her father with her to help her find this drug dealer. Kouri's father passed away a couple of years ago, so this is really moving into fantasy, okay? And so let's remember that there's the civil case. Part of the civil case is a wrongful death action. Remember that there are different evidence admissibility issues, and there are different standards of proof in a civil case. So although law enforcement impounded those things, they still wanted to have a handwriting expert protect them so that when they present those in court, a handwriting expert says, yes, they're really Kouri's, because they can't rely on the fact that they were found in her jail cell and were sent to her lawyer. Okay. So it's just protecting them, making sure that evidence can come in to support their wrongful death claim. So I mean, I think they're being cautious, and their attorneys probably recommended that they make sure that they could overcome any sort of an argument that Kouri didn't write those. So that's a good question. Let's take a last couple. Can you explain to everyone why the family, oh, we got that one. Leah Vogel Simpson, have you talked about the school shooter dad on trial, Colin Gray in Georgia? I haven't. The reason I haven't is because I haven't been able to follow it while I've been following Warner and Richens. It is one that I would like um, to review and talk about. It's just that I hadn't had the time to do it. So that will be on my list for next week. It is interesting that it is a lot like the Crumblies, and more and more states are trying to prosecute parents. We're seeing more attempts to prosecute parents for school shooters. So it is one that I want to look into because we followed the Crumbly case very closely and actually talked at length about their appeals. So I would like to look into it. It's just didn't have enough minutes this week with the other two trials going on. So great. Um, Idaho Mom, I see your comment. I'm not going to post it up, but I agree that it is amusing that the trial tourists are enjoying the Kouri Richins case. But so thanks for that comment. If you know, you know. So, uh, Tiff Knox says Ali Mata is covering Colin Gray on Defense Diaries. Come on over. I love Bob and Allie. Allie is one really smart lawyer, and I admire them both, respect her opinions. So I'm glad that they're covering it, and I will definitely dip in there because I like them a lot. So okay, do we have one last question, or are we ready to wrap up? There we go. Hi, Idaho Mom. Do you think judges may discuss an attorney named Dastin Doe as problematic? I mean, he's changed his name 3 times and is facing charges. Yeah, I think that would be an understatement to say that Dastin Doe was discussed by judges as problematic. I think they probably uh, I think they probably talk about him in terms of, can you believe he still has a license to practice? Yeah, but that could be that could be coming to an end pretty soon. I'm certain that there are judges who look at Mr. Doe and say, "So, Mr. Doe, how long have you been practicing law?" Not counting tomorrow, because he is definitely on the way out. So. I want to thank everybody for being here. If we didn't get to your questions, please be sure that you remind me in the chat and I will get to them. And if you have questions that you would like to send that are not public, you can always send those by email. So I want to thank everybody for being here. I appreciate you all. I know that there are a lot of ways you could spend your Wednesday night, so thanks for spending it with me. I always want to say thanks to Jen, who is the world's best moderator, who I appreciate. Thank you for being such a wonderful community. I think we have an awesome chat, and it's always fun and enjoyable and respectful. So I appreciate you all for that. Thanks again, Jen. Thanks, Hella and Dolly, for being here. Hopefully, I might dip in tomorrow, depending on what happens in the Richens trial. Hella has given me a magic link that I can dip in anytime. And so I'm hoping that I might get a chance to visit with them tomorrow while they do their recap. And until next week, have a safe week and take care of each other. And I'm going to say good night.